understanding and patience. Right, okay, so welcome again to our LLM in Private Law sample lecture with Assistant Professor Mehmet Polat Kalafatoğlu. The title of the sample lecture is Introduction to International Intellectual Property Disputes. Before we start with the lecture, we just wanted to give a brief overview of the program and what we aim to achieve with the students who pursue this program. So the LLM in Private Law aims to give you as a lawyer a broad advanced education in international and European law and deepen your awareness about the links between the different fields of law and their transnational aspects. There are some core or foundational legal courses that you will have to take as a student, and this include international and European contract law, intellectual property and competition law, dispute resolution mechanisms, and World Trade Organization law. So these are courses that need to be taken by all students in the program, whether they choose to do the thesis or research LLM option or the non-thesis option. There are then other elective courses that you can choose from. Some are offered in English, some are offered in Turkish, and they cover different legal aspects of contracts, transactions, dispute resolution mechanisms, taxation, competition, securities, and intellectual property. On the program website, you can see a sample of what are the available elective courses that you can choose from. And of course, the biggest strength of the program is the fact that the people teaching these courses are extremely distinguished professors in their respective areas of specialization, both from Koç University and also invited professors from our partner universities from around the world. The law school at Koç University, it's an extremely well internationally networked community of researchers. So we do have a lot of very important and sustained links with some of the top law schools around the world in Europe, in Asia, North America, and other regions of the world. In terms of the program, there's also a component of writing a dissertation or thesis if you choose the thesis option, or a final paper if you choose the non-thesis option. At the end of the session, as we explained, there will be time to ask more detailed questions about admissions and more from the law school's executive director, Ms. Esra Özcan, who is also here with us today. Finally, one of the key advantages on a practical basis for the program is that the classes are scheduled on Fridays and Saturdays every week. So these allow students to also pursue or continue their careers if they wish, if they're already in Istanbul or working remotely with different law firms or organizations, if they're coming from different countries outside of Turkey, or to use that time for other purposes. So to make sure that we stick to our time for today, I would like to invite Professor Mehmet Polat Kalafatoğlu to join us. And we're extremely grateful for him taking the time to join us today to share his knowledge in the areas of international arbitration law, investment law, alternative dispute resolution, private international law, and international property law and internet law. Today's sample lecture is specifically about intellectual property law. So we're going to hear about him. He joined Koç University in 2016, and he obtained his PhD degree from the Université Paris-Créteil in 2015 in France. So I would like now to invite Professor Kalafatoğlu, and I think our executive director Esra is also raising her hand. Let me just, yes, I need to make him a co-host. Yes, I just realized it. Thank you so much. Let me make both of you co-hosts, and we should be able to get started. So yes.
Thank you very much. Good afternoon, everyone. I hope you can hear me clearly. Thank you for the introduction and also for your kind words. So my name is Mehmet Polat Kalafatoğlu. I'm an assistant professor at Koç University Law School. Today, we will be dealing with the question of international intellectual property disputes. And my idea was to make a short introduction to this course and also to give you an idea about the IP law course that we are teaching, that I am teaching at Koç University Law School within our LLM program. So I would like to try to share my screen with you. And now I think you can see my presentation.
Yes.
Okay, perfect. So, introduction to international intellectual property disputes. As I said, this is a short introduction to the course that I give within the framework of our LLM program. And the name of the course is Intellectual Property Law in a Global Perspective. I think before starting to my presentation, I can give you some information about a brief description of this course so that you may have an idea about the content and also our expectations from this course. So the name of the course, as I said, is Intellectual Property Law in a Global Perspective. And we are making an introduction to IP law with an analysis of different fields of IP rights. And we are also focusing on patent rights, trademark rights, and copyrights. So in this framework, in the framework of this course, what I try to do is to present the general principles governing IP rights, the purposes of IP protection, and especially the enforcement of IP rights pursuant to different regional and international conventions, and also some national laws. And in this respect, we select some issues or some case studies in the fields of patents, trademarks, and copyrights. For example, we are making an in-depth analysis of the question of patentability in patent law. We discuss the protection of well-known trademarks, both nationally and internationally. We deal with the protection of copyrights in the digital era. And finally, we are making an analysis of the resolution of cross-border IP-related disputes in a global perspective. So actually, the presentation that I will be making today is the introduction of the last chapter of my course, and the last chapter is being the international resolution of IP disputes. And maybe a brief information about the assessments that I do in this course. For example, for this specific course, for the assessment of the students, assessment of the participants, I note the active participation of the students. I also give a seminar paper for each student. So each student prepare and present a seminar paper. And finally, we will have a final exam. So let's start to our presentation. Introduction to international IP disputes. First, I think I have to make I have to say a few words about IP rights, and we need to define the IP rights very briefly. As you know, IP rights, they are everywhere. I mean, you may see the novels, you may see computer programs, you may see your mobile phones, music, cinema works, all the brands, all the designs. So this also explains that the IP rights, they are everywhere. And we are using IP rights. We are facing IP rights in our everyday life. And to briefly define IP rights, we can say that the IP rights, they are rights resulting from intellectual activity in the industrial, scientific, literary, and artistic fields. And traditionally, we divide IP rights into two subcategories. We have industrial property rights on the one side, and we have copyrights on the other side. We are making an introduction, so I don't have time, unfortunately, to explain everything about these different types of IP rights, but it is important to note that there are important differences between these different types of IP rights. But I think they have something in common, which is the fact that IP rights gives you some sort of a property right or some sort of a exclusive right over intangible things, such as ideas, such as inventions, such as information or intellectual creations. And IP rights also present a close link with the tangible objects and the intangible IP rights. But these properties, actually, they are distinct, so they are separate from each other. Briefly, IP rights or intellectual property is a creation of the intellectual activity, and the owner of the IP rights can either choose to share this creation freely with the public or freely with the society, or he or she may decide to control its use. Another definition that we find in the doctrine, in the legal doctrine. So I took the definition from Professor Toremans. He defines IP rights as first, property rights. Second, there are property rights in something intangible. And finally, they protect innovations and creations, and they reward innovative and creative activities. So there is always this idea, this objective in IP rights to protect or to reward the innovative and creative activity of the author, for example, or the inventor. Okay, so this brief description or definition tells us that there are three main aspects of IP rights. First, there are property rights. Second, there are property rights over something intangible. So we are protecting the idea, we are protecting the creation. And there is always the idea, the objective to protect and to reward innovative and creative activity. Now, as you know, the title of our course, of our sample lecture, is an introduction to international IP disputes. And before going to the international IP disputes and their resolution, I would like to give you, I would like to make a presentation of, or make an overview of international commercial relations. First, we know that, nowadays, commercial relations, they become more and more international. It is nowadays especially never unusual for a company to do trade with a foreign company, to sign a contract, but we call with a foreign element. Okay, so this is the result of the developments in the fields of communication or in the fields of transportation. But this international environment of contracts, or this international environment of commercial relationships, resulted also a sophistication of the contracts, because now the contracts, these international contracts, they are drafted with more details, they are drafted carefully with lawyers, with teams of lawyers, and this sophistication of the contracts, it also, I believe, decreases the number of the disputes. For example, I can give you another example for the sophistication of the contracts. So nowadays in international trade parties, they usually, let's say, try to refer to model contracts, model documents. So this also creates a sophistication of the contracts. But at the same time, as I said, since the parties, they pay much more attention in the drafting of their contract, this also decreases the number of the disputes. Okay, of course, we are dealing with international disputes, and international commercial disputes, they are also a reality. As I said, that there is a decrease of contracts, a decrease of number of disputes, but at the same time, when we have a legal dispute, we can say that these disputes, they became more complex, and the resolution of these disputes, they require more technical knowledge, more international experience. So now we are dealing generally with international contracts, and we will see these effects, especially for IP contracts and IP disputes. But in this international commercial relationship framework, we can also say that the parties to the contract or parties to the dispute, they need a fast, efficient, and amicable way of dispute settlement, especially an amicable way of dispute settlement. So this is the general idea or general picture for international commercial disputes, okay, or international commercial relations. But the question is, as I said, I mean, parties, they may have a legal dispute arising out of an international commercial contract. And the question will be how the parties, they will resolve this international commercial dispute. So, for example, you may imagine a distribution contract between a Turkish and French company, for example, and then after some years of contractual relationships or commercial activity, parties, they have a legal dispute. I think at that moment, the first thing to do is to contact the other party and try to settle the dispute without the help, without the assistance, or without the intervention of a third party. We always say that in international commercial disputes especially, we always say that a bad settlement between the parties is better than a good litigation. But what happens when the parties, they cannot find an amicable way of settling their dispute? So at that moment, we may think that parties, they need an intervention of a third party to resolve this dispute, okay? But unfortunately, we will face some issues, some problems. First, unfortunately, there is no international court to deal with international commercial disputes in principle. So we do not have examples like a supranational or suprastate or truly international court to resolve these commercial disputes. And for this reason, parties, they need to recourse to national courts. But legal actions or court actions or litigations before national courts, they are not always adapted, or they are not truly adapted for the resolution of our international disputes. Because in such a case, parties, they may have neutrality concerns, they may have efficiency problems, because we know that when you recourse to national courts to resolve this international dispute, there will be some delays. There may be problems maybe with the translation of the documents between the parties, communications between the parties. So this will create also some delays, extra costs for the parties. If you go and claim your rights before a foreign court, well, you have to maybe defend yourself in a foreign language and under a foreign law. And finally, you will be required to represent yourself with or by a foreign lawyer. So for all these kind of reasons, we can say that legal actions before national courts, they are not always, or they are not truly completely adapted for the resolution of our international disputes. And for this reason, we have another option. Another option is an alternative, is to use ADR methods, alternative dispute resolution methods, for the resolution of these disputes, or you can use arbitration. Okay, so these are alternative methods to court litigation. So this is a general picture of our international commercial disputes. Okay, and now let's talk about a little bit with international IP disputes and international IP disputes resolution. So I think one of the most important principles when we analyze international IP disputes is the territoriality principle. And by the way, I saw that there's a question or comment on the Q&A box. So if you have any question, if you have any comment, please do not hesitate. You can simply type in your comment or questions on the Q&A box, or maybe you can also use your microphone maybe at the end, so we can have an exchange of ideas, and I will try to answer to your questions. Okay, please do not hesitate to participate. So we are just making an introduction to our international IP disputes. So as I said, one of the most important principles when we are dealing with international IP disputes is the territoriality principle, because I noted the immaterial nature of IP rights, and this immaterial nature of IP rights leads us to the territoriality of the IP rights, because we know that, and you will be knowing that if you participate to this program, IP rights, they are governed by the territoriality principle, which means that IP rights in principle, okay, they have legal effects only within the state of protection or only within the state of registration. So that's the territoriality principle. Of course, we have some exceptions to this territoriality principle in IP law. So we have the territoriality principle, which gives you either a national or regional protection for your IP right. But at the same time, IP rights, they are also, or they are usually subject of international contracts between the parties. So parties, they sign license agreement, they sign transfer of ownership of IP rights, okay? And when you have a foreign element, when you sign this license agreement with a foreign company, we can see that the IP rights, they become, or the IP disputes, they become a private international law issue, private international law problem. Okay, so territoriality and IP rights that they are making becoming subject of an IP or international contract. And finally, at the same time, we have also the ubiquity of IP rights, because we also know that IP rights, the immaterial nature or immaterial object of the right, has ubiquity, which means that your IP rights, they may exist in different locations at the same time, and they do not have a real physical or geographical localization. You may have a trademark right. This trademark right may be registered around the world, okay? And the products which carry your trademark, your sign, which is protected as a trademark, can be sold in many countries. So these characteristics, I think, they present the need for an international protection for IP rights, okay? But at the same time, this is also the interesting part of international IP disputes. They are also the source of complexity when you have an international IP dispute. So what do you do? Or maybe few words about the different types of IP disputes. When you have, because I mentioned IP rights and IP disputes many times since the beginning of this lecture, of this introduction, I think you also need to define the types of IP dispute, okay? Because you have different types of IP disputes. You may IP disputes involving an administrative nature, or you may have IP disputes involving civil or private nature or criminal nature. So you have to define the nature of the dispute at hand. For example, in every national law, it is possible to have some sort of a review mechanism, like an internal appeal mechanism, when you apply for example, registration of your trademark right before your national IP office. Okay, so for example, under Turkish law, you apply for registration of your trademark to the Turkish Trademark and Patent Office, and there may be an internal appeal mechanism within this administrative unit. Okay, so at that moment, this dispute will have some sort of an administrative nature, I think. Okay, then we have also reviews made by the state courts against the decisions of the IP offices. So it may be a review before granting the IP right, so before the registration of the IP right, if you are dealing with patents or trademarks, for example, and there may be also disputes after the registration, so post-grant appeals, okay? Which means that in most of national laws, the state courts, they have also an important role, an important authority for hearing appeals against the decisions of IP rights, IP offices, national IP offices, okay? And then we have all kinds of exploitation disputes. We have disputes arising out of IP contracts, for example, license agreements, okay? We have all kinds of infringement disputes, either before civil courts and or before criminal courts. So for example, if a third party infringes your trademark right, it is possible to initiate an infringement legal action, either, as I said, civil infringement or criminal infringement action, depending on the applicable law. And finally, we have disputes over the validity of the IP rights. So we have what I call the nullity or revocation procedure. So these are different types of IP disputes. Okay, these are different types of IP disputes. And what is important with this international IP disputes and international IP dispute resolution is that these disputes, they have some, let's say, specific needs, and there are some specific interests in questions. For example, now if you think of a purely domestic or national dispute, but national IP dispute, then, as I said, the first option will be to use the state courts. But if you go and initiate your legal action before state courts, I think the choice of this option will bring some complexities, okay? Because for the purely domestic, we can also say this one, for the purely domestic or national disputes, because IP disputes, either a patent dispute or copyright dispute, they require a need for specialization. So that's why, for example, it is interesting to see that in different legal systems, you may see specialized IP courts. Okay, so for example, we have example under Turkish law, but I'm sure that I know that to resolve these IP disputes. A typical example will be a patent dispute. So, I mean, technical expertise will be required. So that's why national laws or states, they create specialized IP courts. Okay, so this is a valid argument for the purely domestic disputes, but also it is valid. It is also valid for international IP disputes. But when you have international IP disputes, we have more complexities, because when you have an international IP dispute, so an IP dispute involving a foreign element, as you know, there will be questions of applicable law. So which national law will be applicable to this dispute, and which national courts have jurisdiction, international jurisdiction for these disputes. Okay, so these are all the private international law aspects, but we need to also resolve these or answer to these questions in the field of IP, international IP disputes. Okay, applicable law, international jurisdiction of state courts, and also as the final aspect of private international law, the recognition and enforcement of foreign court decisions, okay, in the field of IP dispute. Because depending, again, I'm referring to my previous slide, because depending on the type of the dispute, we will have different rules of jurisdiction and different rules of applicable law. And finally, we may have parties, they may choose alternative dispute resolution for the resolution of their IP dispute. Okay, so the second option will be the use of ADR. And in this respect, we have different types of ADR methods to resolve IP disputes. There are some ADR methods specifically designed for IP disputes, and we have also traditional ADR methods such as mediation or arbitration. You can also use or opt in for these methods for international IP disputes. Maybe I can make some make a historical or explain the historical background a little bit, because the use of ADR for the resolution of IP disputes, they goes back to the 19th century even, okay? But it is also interesting to see that arbitration, especially, was seen in the past as a closed or as a forbidden territory for the international IP disputes. We can see that the IP right owners, they were somehow reluctant to use arbitration for the resolution of their dispute. But interestingly, IP disputes, I think they played a major role in the progress or in the development of international arbitration as an international dispute resolution mechanism. For example, maybe you know that there are a method called what we call expedited arbitration rules. For example, the expedited, so a fast track arbitration procedure. So expedited arbitration rules prepared by World Intellectual Property Arbitration and Mediation Center was, they were one of the first examples, okay, of fast track or expedited dispute resolution. And other arbitration institutions, they also followed this example because the parties need for a fast, efficient, expedited dispute resolution procedure was also available or primarily available in IP disputes. Another example is the UDRP, for instance. UDRP is a typical or specifically designed ADR method for internet domain name disputes. So trademark infringement, online trademark infringement, and with the use of domain names, internet domain names. So the UDRP method was maybe one of the first fully, completely online dispute resolution method, okay? And it was designed for IP, specific type of IP disputes. And then it worked very well, successfully in this kind of disputes. And then we also used online dispute resolution methods for other types of dispute, even in purely commercial disputes, okay? Another aspect is that there is also the fact that you can find a favorable environment for the use of ADR in national laws or in international conventions. So, for example, we have a Turkish IP code, we have an article which encourages somehow parties to use mediation, okay? Another typical example for the use of ADR in IP disputes is that the ADR services of the EU IP office for mediation during the appeal proceeding. So this is also shows us that national laws, international conventions, regional conventions, they also create this favorable environment for the use of ADR in the resolution of IP disputes. And most common examples of ADR for IP disputes, we can say mediation, expert determination, and arbitration. So this is a very brief introduction, and maybe as a last word, I can say that this is a very short description or introduction to the very last chapter of my IP course. But what is interesting to see that there are different types of ADRs for IP disputes, but also it is essential to study the limits of using these ADR methods in resolving international IP disputes. For example, obviously parties, they may select arbitration for the resolution of their international IP dispute, but there are also some limitations for the use of arbitration for these disputes, okay? So for example, we need to examine, then we have to go back to the types of disputes, and we have to examine whether our legal dispute, the type of the legal dispute, is suitable or is permitted for arbitration by national laws or by states, okay? So, and that will be my last word for this introduction, and then I will check the questions and comments. So there will be also limits coming from national law for the use of ADR, including arbitration, in resolving international IP disputes. Okay, so that will be my very brief introduction. I hope I didn't
No, that's absolutely perfect, Professor. Because
so let's maybe check the questions.
Exactly, there's great questions on the question and answer section. Would you like me to read the questions and then you answer them?
I can read them.
Okay, all right.
First one, first question: how do intellectual property disputes impact in developing countries like Somalia's economy? So this is actually a question which is related to protection of IP rights and also resolution of disputes, because IP rights, I mentioned the territoriality principle. I said that in principle, we protect IP rights on territorial basis, on national basis, but obviously there is a need for protecting these IP rights on the regional and international level. So that's why there are many regional and international conventions protecting and enforcing IP rights at the international level.
Thank you. As you answer them, I will mark them as answered so we can see the next one.
There's another question. My question is, how often there's arbitration in regards of IP disputes, and is there a shift from court litigation to arbitration? Ilyas Yusuf's question. Thank you, Ilyas, for your question. So, I mean, starting with the last part, I think, yes, there is a shift from court litigation to arbitration. And I think the trend is that the parties, especially IP right owners, they became much more familiar with different ADR methods, and they start to use it much more often. For example, you can see, you can check the statistics prepared and presented by international IP institutions, okay? And for example, if you check the WIPO's statistics, you can see that there is a considerable increase in the number of the disputes every year per year. So yeah, I think there is, I mean, IP rights, IP disputes, they are became much more popular for ADR as well, I think. There is another question. How can a company protect its IP rights and prevent infringement by competitors, particularly in the digital age where information is easily accessible and can be easily duplicated or distributed? This is Abdurrahman's, Othman's question. That's the perfect question. So, of course, I won't be giving the answer to this question, but this is the reason that we are discussing during the last part of our course, of my course, that we are discussing the international IP dispute resolution. Because, as you said, there is a need for protecting IP rights at the international level. And with the digital age, of course, this protection became much more important because, I mean, the infringers can be everywhere around the world. So this also, let's say, initiates some very interesting, serious questions about the using court litigation or ADR method. So typically, for example, the UDIP that I mentioned is a solution for this kind of IP disputes at the digital environment. Okay, it works very well, but it is only for a limited types of dispute. So it should be an internet domain name dispute for a trademark infringement. Okay, but for example, in our classes, I start my last chapter by saying that, is there any efficient dispute resolution method for IP disputes? So that's the question that we ask. Okay. Okay, Daria, what role do international organizations such as WIPO play in resolving international intellectual property disputes? They play a very interesting and very important role. For example, WIPO has a arbitration and mediation center. So WIPO itself offers this dispute resolution mechanism. Okay, so that's why they, of course, they also organize conferences, reports, legal reports, I mean, or they involve in the, let's say, drafting of international texts or regulations, but also they offer this dispute resolution services. So if you check WIPO's website, you will see that the WIPO Arbitration and Mediation Center, you can find the statistics, and also you can see different ADR methods that they are using, they are offering for the IP right users. Okay, so it will be questions and questions. So let's continue. Thank you so much. Thank you for your comment. You have pointed out that we do not have a super international organization for solving commercial disputes. I want to ask, what exactly is stopping us from making one? We do have WTO, ICG, and even the ICC. I mean, you mean International Criminal Court here, I think. Why not one for international commercial disputes? Well, thank you, Ali, for your question. So, and also you complete somehow my presentation, because WTO dispute resolution is also a way of protecting IP rights and a way of protecting, a way of resolving IP disputes. So, for example, as you know, we have WTO, World Trade Organization agreement, and we have also the TRIPS agreement, okay, trade-related aspects of IP rights. But when you have a WTO dispute involving an IP right, this will be still a legal dispute between two states, okay? And I mean, we are dealing with international commercial disputes or international private disputes between two private, for example, two companies. So, unfortunately, we do not have such an international or super-state court mechanism. And the only, I think, the two answers which comes to my mind is that first, these are commercial disputes. Second, we have international arbitration and also other ADR methods. And arbitration, for example, it works very well for this kind of international commercial dispute. So that will be my answer.
I think we have four more questions, and then we will wrap up, but they're great questions, I think. So thank you, everyone who has participated.
Thank you very much for your questions and comments, Can we do research on IP rights that are only applicable within territorial boundaries of Pakistan, specifically Punjab province, since ADR Act 2017 is implemented here? When you say, I think this is for the way of this.
I think it's referring if the thesis topic, for example, could be related to that. Or a final paper.
Well, if you
maybe Sohail can clarify what he means by research.
Yes, I mean, Sohail, if you want, you can also clarify your question. But if you are asking for a thesis subject, of course, I mean, we are discussing international disputes. It is also always important, I mean, for me to make a comparative law analysis. That may be interesting, but I mean, as long as first you compare with another jurisdiction, another national law, I think if it is purely on national law Pakistan, I think, yeah, we may discuss it, but yeah, otherwise, if you make a comparative law analysis, I think that will be okay. Ali's comments. Yes, maybe I can briefly read the comment. Also, the disclosure of detailed information about an IP property during litigation raises the possibility of potential infringement by others. This is because during the litigation process, and finally, I mean, he mentions the confidentiality, and then the question is, how can organizations aiming to navigate issues handle these? This is also a perfect question, because one of the main advantages of arbitration and also for IP disputes is the fact that arbitration is confidential in principle. So the dispute, the procedure is confidential, and the decision of the arbitrators also confidential, and there are many mechanisms to protect the confidential information involving an IP right during an arbitration procedure, for example. There is Abdurrahman's question, but I mean, this is very related to trademark infringement disputes. I think this will be outside the scope of this presentation, so maybe less. I mean, but you have my email address, so do not hesitate to send me an email. Okay. Agustina's question. Thank you for allowing me to join the session. I would like to test some matters. I really want his opinion. Due to the explanations, it was needed to recourse to national courts. In fact, many court officers, here in Indonesia especially, didn't really have the capacity to determine the technical problems in the APR matter between the parties. What your suggestion to this court officer? So you are very correct that, as I said, IP disputes especially, they require technical expertise. And also, if you take the patent disputes, for example, they also require technical knowledge in that specific field of technical activity, okay, or science, for example. So that's why, yes, we need technical expertise. In that respect, for the court litigation, there are, some options, either to create some specialized courts or appoint legal experts, technical experts in the court litigation, or you can also do both options, of course, both solutions, but these are for the court litigation. But the thing is, in arbitration, you can select arbitrators having this technical knowledge already. So you can select your arbitrator for this specific dispute. You can select you can select someone who is not a lawyer, okay? You can select an engineer to act as an arbitrator in your legal dispute.
There's 2 more questions and then we will wrap up. They're great questions.
Okay,
so, yeah.
Thank you very much. So Nigel Mazima's question: with the emergence of AI, artificial intelligence that can create code and make intellectual property, is there a way of safeguarding one's own intellectual property against artificial intelligence? Well, this also goes beyond the scope of this presentation. So the protection of IP rights or enforcement of IP rights and all the legal issues created with the artificial intelligence. We discussed this during our classes, but just, it's an interesting coincidence, I think. For example, I have a student who is, your colleague, and she will be defending her thesis on the protection of IP rights created by artificial intelligence. So she will be defending her thesis tomorrow. So LLM thesis. So that's also a very interesting question, I think. Thank you.
Thank you very much. So I think we can read the last question from Zeynep, because the last one from Daria, I think it's very similar to the question regarding AI.
Thank you. And Zeynep's question, my question is, what is your opinion about the relationship between competition law and IP law? I saw earlier that in the core course it says IP competition law. It makes me curious about the link. Thank you, Zeynep, for your question. So I think in the presentation slide, there was also an information on competition law, because there is another course on competition law. So maybe Esra Hanım may correct me if I'm mistaken. But if you especially focus on IP protection and IP enforcement, as you know, a way of protecting IP rights is also initiating unfair competition legal action. But the competition course that was mentioned on the introduction slide is related to the competition law course, I think. But I maybe, yes, so she confirmed. And yeah, I think that will be all. If there is another question.
Yes, that is all, Professor. Thank you so much again for your time today. I think the participants enjoy this kind of introduction to a very rich, very complex, and very dynamic topic that seems to be evolving and changing very quickly. Last couple of just information for our participants today. There will be another sample lecture related to our LLM in public law that it's going to be delivered on the 26th of May by Professor Bertil Emrah Oder, who is the Dean of our School of Law, on the topic of law under pressure, a new era of decline and progression. She's a professor of constitutional law, so this is also looks like it's going to be a very exciting and enlightening sample lecture. And then on the 2nd of June, we will have a broader information session about both the public law and private law LLM programs with Ms. Esra Özcan, who is here today. In that session, because we have run out of time today, we will be discussing in detail all the questions regarding the course structures, the classes, the admission requirements, admissions process, tuition, and more. Just as a reminder, the application deadline for those of you who are interested in applying for admission to our fall 2023 intake, which will start in October this year, is the 23rd of June. All of those details, of course, are available on both the Graduate School of Social Sciences and Humanities website, which you can see on the screen now. If you're an international participant today, you can check more resources specifically for international applicants on our internationals website. And as I said, you will receive after today a link to the recording of this sample lecture that you can check at any time, but you can also check it on our YouTube channel if you simply type Koç University International Admissions. If you have any questions after today, you can find on the screen our email addresses for international applicants and for Turkish or domestic applicants. And I hope that this was a useful webinar for you. I feel it was, based on the the great questions that we received. So thank you so much again. If there are no other, I think Professor Polat needs to go, but if there are no other questions, let me just check. Okay, so thank you, Seda, for your comment. We will then wrap up. Okay, thank you very much and have a good afternoon or good morning, wherever you're joining us from. Thank you. Bye-bye.